morning, everybody. We're going to go ahead and get started. Welcome. Thank you all for coming today. And for those of you who are joining us online, we appreciate you being here. Just a reminder, part 2 of the seminar is February 26th. That session will be in the afternoon from 1 to 4, and there will be a little reception following. So we hope to see you back here in 2 weeks. We have a really good presentation for you today. We have 3 really good speakers. I should introduce myself. I'm Susan McNamara, and I have the pleasure of co-chairing the Title Standards Committee with Ami LaTourette. And Ami is actually our first speaker this morning. Ami is a partner at Schulten, Ward, Turner & Weiss, LLP, where she practices commercial real estate and business law. And she is going to speak to you this morning on affidavits of truthiness. So, Ami, come on up.
Good morning, everyone. Being here first thing in the morning. We're going to talk today about affidavits, and to make it a little bit more fun, we're going to talk about them in the context of truthiness. So,
Should be able to just press the down button.
technology, great. Most of the time. All right, so about me, my name is Ami LaTourette. I'm a partner at Schulten, Ward, Turner & Weiss, where I do commercial real estate. I started law school. I worked as a real estate paralegal, actually, doing residential real estate, primarily default work. And I had the pleasure of working with 2 fantastic attorneys, Kristen Rioja and Carl Alford. And this presentation is dedicated to them. They're actually the ones who came up with the term affidavit of truthiness after we had to deal with a sovereign citizen. If you've ever had to deal with a sovereign citizen filing, you understand the idea behind an affidavit of truthiness. So our agenda for today, we're going to talk about affidavits generally. We're going to talk about relevant title standards because this is the title standards seminar, so we have to work that in somehow. And then other uses for affidavits in title practice generally. So let's start at the beginning. What is an affidavit? An affidavit, according to Black's Law Dictionary, is a voluntary declaration of facts written down and sworn to by the declarant before an officer authorized to administer oaths. Seems pretty straightforward. But what is truthiness? Well, truthiness is actually a real word. It's in the dictionary. So it's not just something that Colbert made up, although he is the person who came up with the word. And Webster defines it as a truthful or seemingly truthful quality that is claimed for something not because of supporting facts or evidence, but because of a feeling that it is true or a desire for it to be true. So what is an affidavit of truthiness? I define an affidavit of truthiness as a voluntary declaration, generally detailing the declarant's opinion or viewpoint rather than an objective or verifiable fact, which was written down and sometimes notarized, sometimes a sworn statement. That's my definition. And for those of you lucky enough to never have run into a sovereign citizen filing, this is kind of what it looks like. So I think everyone's seen an affidavit, hopefully, before. This is a sovereign citizen affidavit, or what we call an affidavit of truthiness, where it seems to state things that look like they might be facts, but when you actually start reading them, don't really make sense, somewhat incoherent, and it may be a factual statement, but the next line doesn't connect to the previous factual statement, and the whole thing just doesn't really make sense. So that's a good example of an affidavit of truthiness. So what should we expect and accept with respect to an affidavit? You don't want an affidavit of truthiness. This is an example of what you don't do. So what do we do? Well, Title Standard 6.1, because again, we're here at the Title Standard seminar. Title Standard 6.1 covers affidavits in general. And Section A says, utilization of affidavits is an acceptable practice and reasonable reliance may be placed thereon. Proper and recorded affidavits constitute notice of the facts recited therein and create a rebuttable presumption that such facts are true and correct. And then Section D says affidavits should be given under oath or and attested by a notary public or other official authorized to take an oath. It's pretty standard, right? And this is in line with just the Black's Law definitions of an affidavit. So what is required for a proper affidavit, a proper and recorded affidavit? In order for it to be proper, we know, according to the definition, it needs to be a statement signed by the affiant, notarized, and then it needs to be reportable. So our basic reportability standards. It needs to be on letter size or legal size paper. It needs to have your blank 3-inch margin at the top. It needs to have your return to information, identifying a natural person. It needs to have wet ink signatures. And in some counties, it needs to have your parcel ID number. Don't forget, Fulton, DeKalb, and I think Chatham require a parcel ID number. But practice is to just put a parcel ID number on all your real estate documents. And you need to pay the recording. So some things that are not needed. You don't actually need a legal description. You don't actually need an unofficial witness. I know we're used to having deeds that are signed by the maker and attested to by an unofficial witness and an official witness. You don't actually need that for an affidavit. And you don't need, this is my little rant, you don't actually need the correct parcel ID number. I mention that because sometimes in an affidavit context, you don't necessarily have a correct property to describe. That might be the reason that you're giving this affidavit, right? Is, hey, the property descriptions that are out there are wrong. Or the property descriptions don't describe what we're trying to do. But what else should we have in an affidavit? Well, going back to Title Standard 6.1, affidavits in general. Section B says affidavit should reference the current property owner and a recorded instrument in the chain of title. Affidavit should address the entire issue, which is the subject of said affidavit. It should state facts rather than conclusions, not be worded so as to mislead or leave unanswered questions. So here we're really saying that it should be a statement of fact. Again, this is a real affidavit, not an affidavit of truth. And Title Standard 6.1c goes on and said affidavits may be made by any person, even those connected with the chain of title, and should be set forth information within the personal knowledge of the applicant. I think this one is very important to note because this is one of the few times where you can accept statements made by a person who has an interest in the property. Okay? Most of the time, we're looking for extrinsic information that has an indication of value outside of a reason why someone related would want to make a statement. So who can be the affiant? An affiant must be an individual who can make the sworn statement. So for example, I, John Smith, do hereby make the following statements of that. I probably should have picked a woman. Maybe Jane Smith should have made that statement, not John. What about people who are not making a statement in their individual capacity? What if they're in a representative capacity or they're making it on behalf of an entity? Well, let's talk about representatives for a moment. If the affiant is acting in a representative capacity instead of their own behalf as an individual, then the capacity can be included as a statement of fact that the affiant makes. So example, I, John Smith, make the following statements of fact. I am the manager of XYZ LLC. I'm making the following statements in that context. But truthiness tip. An entity cannot make a sworn statement. Only a natural person can make a sworn statement. So think about whether or not the party who's signing the affidavit could raise a hand and swear an oath to tell the truth. Fine if you have an individual who is making an affidavit in their capacity, in their representative capacity, but an entity can never sign an affidavit because they can't make a statement, right? They have to act through an individual. They have to be having their manager or their president or someone make the statement on the entity's behalf. And for anyone who thinks that's silly, I have had very large law firms argue with me that their clients always sign affidavits in their entity capacity and not in their individual capacity. That is incorrect. It needs to be in the individual. I always think about it. If you can't raise your hand and swear an oath, if you can't hold the pen yourself, you can't sign an affidavit.
Quick question, is the I am manager of LLC correct or not?
Correct.
That is-
That's a statement of fact that you would make in your affidavit. So the
So
manager,
in it, he's signing as an individual, but naming his capacity.
and Title Standard 6.1 actually says this in the comment section, 6.1C. Says the affidavit may set forth in the body of the document that the affiant is acting in some capacity, source of authority or insight as to the facts set forth therein. So again, you would make the statement that I am acting in that. However, the facts recited are to be those personally known to the affiant and not known to a corporation, grantor of a power of attorney, or other represented person or entity. And no corporate title or the representative designation should be indicated for the signature. So in our example, John Smith, the manager of XYZ LLC, would sign the affidavit just as John Smith. He wouldn't sign manager, XYZ LLC by John Smith.
And doesn't it generally in the closing in my individual capacity right above the signature, or does it sometimes bring that in?
Yeah, a lot of times when you have parties who are negotiating that, they will say John Smith solely in my capacity as manager. That's to limit the liability of the individual. So you may have an LLC agreement that gives the manager indemnification through the operating agreement, for example, or other forms of indemnification. It's not going to save that individual from liability for perjury. So if they're just lying on their affidavit, they're still subject to it. But if they're making a statement because they're misinformed by the entity that they represent, then they may be indebted. So let's next look at a bit of a tricky issue, and these are knowledge standards that can be used in that. Typically, the affidavit should be made, or the affiant should be making statements of fact based on the affiant's actual knowledge. So this is what they know. The drafter of the affidavit should be careful to draft the statements in such a manner that they fully and completely lay out the facts without requiring a knowledge qualifier. So you can phrase things in a way that takes it and makes it a statement that the person can actually say. So John Smith may not be able to say that the corporation has never had a lawsuit against it, or the entity has never had a lawsuit against it. But he can say that during my time as a manager, I have never been served with a loss. That's a statement he can make affirmative. Alternatively, maybe he makes a statement that says, to my knowledge, the entity has never been served with a loss. And that would be an example of a knowledge qualifier used in an affidavit. The better practice is to have somebody make statements of fact based on their knowledge. And so you want to phrase it in a way that the statement is true for them. And another truthiness tip. If a knowledge qualifier is needed, the affiant may not be the best person to give the affidavit. But sometimes there may be a good explanation for why the affiant needs to qualify their statement, and why no one else is in a position to have better personal knowledge of the facts. So again, John Smith may be able to say that during my time as a manager, no lawsuit has been served on me. That'd be a good statement. He may need to make the statement that, to my knowledge, no lawsuit has been served on the company, because he's the only member of the company, or he's the only person who's ever served as manager. And there may be a context where that's necessary, but it would be better to have it limited to what he actually knows. Now, there may be some time where you have somebody who doesn't have, where we don't have anybody who has better knowledge. A great example of this is in the estates context, where the former owner has died. And so the only people who are left are the heirs who are being called on, or people who were familiar with the owner during their life. But we no longer have the owner to make statements of their knowledge. So the heirs should be making statements of fact to their knowledge, but there may be occasions where we want the statements to be broader, no longer things that the heirs themselves know. For example, we may have an affiant who's a neighbor, and they may not be able to say that the owner only had 3 children. They may be able to say that he told them he only had 3 children. That would be a statement of fact to their knowledge. But they may not be able to say that he only ever fathered 3 children. There may be a child that is unknown to them. Again, this is not somebody who necessarily has the personal knowledge, but we're trying to phrase things in a way that it is true of their personal knowledge. What do we hit? And title standard 6.2 gets into this a little bit, right? Actual recitals in conveyances are widely utilized, but such recitals do not comply with the statutory requirements of an affidavit. So y'all have deeds that we've done where you start off and you're reciting something. Maybe you're giving a little bit of the background. Those also could be statements that you could make in an affidavit, but within the context of your deeds, your conveyances, those are not statements that are considered made under oath. And those recitals should be relied on for information, purposes of information and not in lieu of them. They do, however, have certain conclusive presumptions regarding recitals and conveyances as against the grantor. Remember, think back to evidence. I know it's a long time ago. Think back to evidence class. Statements against interest have a evidentiary weight to them. So if the grantor is making statements of fact that would maybe go against their interest if they were untrue, that may be an example of a statement that has a conclusive presumption. And there's also assumptions against those entities under the grantor. And regarding recitals in ancient deeds, which are deeds more than 30 years old. Recitals are most useful when they're supported by matters of public record other than the record. So what is title standard 30.2 really talking about? recall that recitals in deeds are not incorporated into the deed themselves, right? So they're not actually part of what the grantor swears to when they make the deed. And that's not part of what the notary is attesting to. The notary is attesting to the intent to create the conveyance in your deed, and not the factual information of the recitals. Yeah, when we're talking about affidavits, we're looking for the factual information of the recitals. I'm sorry, the factual information that the affiant is making. The title standard, going back to title standard 6.1, this is the last bit of A, and I kind of made these a little out of order because I think they made a little bit more sense in the context. So title standard 6.1A, we've already talked about, but the second part of it says, however, absent extraordinary circumstances, affidavit should not be utilized in lieu of normal conveyancing, probate, or judicial procedures. So you can't use an affidavit to convey property. You can use it to include certified copies of death certificates, marriage certificates, birth certificates, but we really want copies of those certificates themselves. Those speak to matters of fact better than a mere statement from. But maybe we have a situation where we have joint tenancy with right of survivorship, and one of the joint tenants is deceased. And now we want to make sure that that information is put on record so that the joint tenancy is severed by virtue of death of one of the joint tenants. We can use an affidavit for that. And we talked about this earlier in title standard 6.1, where it's useful to reference the current property owner and a recorded instrument in the chain of title. This would be a great time to file an affidavit that says, John and Jane Smith, husband and wife, took title as joint tenants with right of survivorship by this deed recorded in this deed book and page. And John is now dead. A copy of his death certificate is attached as Exhibit A, and cross-reference that to the joint tenancy deed. That way, Jane Smith is the only owner of record. And you can refinance the property or have her sell it, whatever you need her doing with the property. So what else can we use affidavits? Well, title standard 6.3 actually covers affidavits of possession. We start getting into specific uses for affidavits in the next title standards. An affidavit of possession is an affidavit of the history of the possession of the property and should set forth the period of time with which the affiant has been familiar with the property, the names of the current or prior owners of the property of which the affiant has knowledge, and the indicia of the ownership upon which such knowledge is based. The affiant may be a party in interest or a disinterested party. So again, a lot of times in real estate, we're looking for disinterested parties because they're less likely to lie to us. But sometimes for an affidavit, the only people who are going to have knowledge of the facts are people who are related to the titles. So the comment goes on and says the underlying purpose of such affidavit is to establish adverse possession, and the affiant should normally be familiar with the property for not less than 7 years. And this may dictate still longer. Remember, if you don't have color of title, your period of possession for adverse possession is not 7 years, it goes up to 20 years. So you may need somebody who's been familiar with the property for 20 years if you have somebody who's simply squatting on the property. And then an affiant may be a party in interest, but preference should still be given to one having no interest in the property. So maybe you have a situation where you have a party who has adversely possessed the property. They're going to have the best knowledge and the best statements of facts about things like when they took possession of the property, how long they've been there, that no one else has made a claim against their possession that could defeat an adverse possession. Again, somebody who has an interest in the property has reason to give a false affidavit. So you may also want to have an affidavit from someone who is interested party, a neighbor, who can say things like, I don't know when they moved in exactly, but I know they've been there for at least 10 years. I don't know if it's 10 or 13 or 15, but I know it's at least 10 years, definitely more than 7. And that would be a great affidavit to back up the affidavit that you're already getting from the party in possession. So another truthiness tip, who says, again, you can accept an affidavit from a party in interest, but watch out for who is giving the affidavit and the motive for giving the affidavit. Because people can, and they will, lie to you. While the title standards make it clear that an applicant can be a party in interest, you may not want to rely solely on their unsubstantiated statements of fact, especially if that basis or if that statement is the basis for your legal advice. So again, in an adverse possession context, if you're relying solely on the statement of the party who has adversely possessed it to say that they have good title to the property, your statement that they have good title to the property is legal. Your basis is their statement of fact, where they could be lying to you about it. You may want to go get a second opinion, second party who can make a statement, and you may not want to say that that party is vested in title if you don't have that outside information. All right, other uses for title standard or other uses for affidavits. We have title standard 6.4, affidavits of descent. We have documentation of family history of a deceased holder of record title and potential heirs thereof establishes that all parties have been or should be properly divested. Such affidavit should state the residence, the date of death, testacy or intestacy of the deceased, should identify all spouses, indicate the death with or without issue, identify children and grandchildren, and disclose respective dates of death or addresses and disabilities as applicable. It goes on and says the affidavit should identify the number of marriages, including the date, place, and evidence thereof, i.e. marriage records and court records or lack of knowledge, how marriages were terminated, i.e. death or divorce, including the style of the case, decree date, case number from which the court obtained any other relevant information. And the affidavit can also include issue by birth or adoption. And if adopted, such information can be obtained including birth certificate. The affidavit should indicate whether all debts, including the estate or inheritance taxes, have been paid. And then the comment to Title Standard 6.4 says affidavits of descent will almost always need to be from someone in the family of the decedent, and therefore very well could be from a party in interest. This fact should not detract from the reliance placed upon the affidavit. Let's go back and look at this a little bit more in depth. Affidavits of descent are great information regarding family history. You have a deceased party, and you're going maybe through probate or trying to determine if probate is needed. And who all do you need to get into probate? So an affidavit of descent should document family history. Most of the time, the best people to tell you who the members of the family are and the family history are going to be family members. The people who show up for Christmas, for Thanksgiving dinner, going to be the people who are there for the birthdays and unfortunately for the death. So those people are probably also going to be heirs at law, and therefore they're going to have an interest in the property. So that's why this title standard does say that you can take an affidavit from someone who has an interest in the property or may have an interest. And we can use this information for lots of things. Okay, again, we're not just talking about the death of a party. We can talk about who their heirs are. How many children did they have? I have had situations and seen situations where when you start probate, there was maybe a blended family and the kids from the second marriage didn't like the kids from the first marriage. And so they only counted their siblings. And on the probate affidavit, they said, mom's kids were me and my brother. They left out their stepbrother they really didn't like because they didn't think the stepbrother deserved anything. That's not a complete statement. So in such cases, it may be helpful, again, to go get multiple affidavits instead of relying just on one. You may have situations where one child knows more about their parent, especially things that the parent didn't want to tell younger children. So maybe one child knows more information than the other children. So it's not that the other children would be making untrue statements in their affidavit. They simply didn't know. And again, affidavits should be statements of fact based on your actual knowledge. So Title Standard 6.4 also talks about the number of marriages. How many times were you married? What happened to your spouse? Were they divorced? Were they dead? If you see a pattern where spouses keep dying, that's a whole other question that we're not going to get into. But it is important to establish who the spouses are if they are still alive. That can indicate how many children they had, heirs, who you need to go get affidavits. Maybe somebody was divorced and is now remarried. Maybe you want to go get an affidavit from the ex-spouse about how many children they had together. Okay. So affidavits of descent, again, can be from people who are interested, almost always will be from people who are interested, and can cover a lot of information about the family history, the family. But what about other uses? Title Standard 6.5 covers Scrivener's affidavit. Unfortunately, I think most of us have had to do a Scrivener's affidavit. We're all human. We are subject to mistakes. So Scrivener's affidavits can be utilized by the preparer of a document or other party in a valid position to know to correct clerical errors when the original parties are unavailable. Such corrections should be unquestionably the original intent of the parties, should be minimal in extent, and should be supported by extrinsic evidence if called into question, and should be reported. So examples of what's acceptable for a Scrivener's affidavit. Maybe there's a typo on the legal description about the land lot, and we typed 113 when it should really be 133. And that information that it should be 133 is evidenced by the recorded plat that we referenced in our legal description. That is a good use for a Scrivener's affidavit. But truthiness tip, before you use a Scrivener's affidavit, you need to check, is that what we meant to do? Not all typographical errors are minimal in extent and supported by extrinsic evidence. So for example, well, you can correct a land lot discrepancy that is clearly indicated by the record or your chain of title. A lot number error is rarely something that can be corrected by a Scrivener's affidavit, especially if the plat shows more than one lot. So if you're referencing a subdivision plat and you wrote lot 3 and it was supposed to be lot 30, there is a legitimate question of the intent of the parties about what they intended to convey. Because that's not something that you can identify from the plat if it has both lot 3 and lot 30. And you must be especially careful if the plat shows more than one lot or if the seller owns more than one lot in that subdivision. If you're representing the builder and they own both lot 3 and lot 30, you absolutely can't say with certainty that their intention was to convey lot 3 and not lot 30 and use that as a scrivener's error. Better practice. I know it's a pain. Go get a corrective deed. Go get the parties to re-sign a deed saying what they actually intended. That reaffirms the party's intent to make the conveyance and protects you as the attorney from making that statement on their. And another truthiness tip. Are you actually the scrivener? Remember, in order to use a scrivener's affidavit, you should be in a position to have personal knowledge of the original intent of the parties to the document. And if you don't have that knowledge, you weren't the closing attorney who closed the deal for them, if you didn't talk to them about what they were meaning to convey, if you have any question about what they meant to convey, like they owned, again, both lot 3 and lot 30, then you're probably not in a position to act as the scrivener for the scrivener's affidavit. You may be in a position, however, if there's still extrinsic evidence, to do an affidavit of title to recite the clerical error or what the correct information should be. So maybe you weren't the closing attorney, but the chain of title makes it very clear that lot 3 is only what the seller owned, it's all that the seller ever owned. Street address lines up. There's another affidavit out there that says that they mortgaged lot 3 and they intended to sell 123 Main Street, which is lot 3. If you have all that evidence lining up, you may not be the scrivener because you didn't do that conveyance and you weren't there to know what their intent is, but all of the other evidence is lining up and you can give an affidavit of title to acknowledge those facts and to recite those facts that you have found in. Another example is in the adverse possession context. The possessor, I don't know when that went back there. So let's talk about affidavits of title to land. This is actually statutory. It's not part of the title standards. It is covered by OCGA 44-2-20. And affidavits of title to land can be used for a lot of things. Recorded affidavits shall be notice of the facts therein recited, whether taken at the time of the conveyance of land or not, so before or after. And they can show, got a list of 9 things, okay? They can show the relationship of the parties or other persons to conveyances of land. They can show the relationship of any party to any conveyance with other parties whose names are not shown in the chain of title to lands. And they can show the ages of persons connected with the chain of title. So let's talk about some examples about 1, 2, and 3. Item number 1, the relationship of parties or persons to conveyances of land. This may be relationships of people. Maybe we're reciting that this person was the only child of the grantors or the grantees. For number 2, the relationships of any parties with any conveyance for other parties whose names are shown in the chain of title. Maybe we're reciting who the neighbors were. If there's a boundary dispute, it would be really helpful to know who the neighbors were. So we can go find the neighbor's deed and know where the neighbor's claim ended versus where our property line is claiming up to. It can be a list of the relatives or the heirs to the property. And then number 3, age of any person. That seems kind of a weird statement, but it may have relevance. It may show you something like John Smith Jr. is 93 years old. So it's very unlikely that he's the guy who just inherited the property from his 82-year-old grandmother. Weird to be older than her. Or it may say that John Smith is a minor and he is currently 8 years old. And so we know that in 10 years, or it's been 10 years since that affidavit was given, he's now of age. He's now reached his majority and he can now deal with the property himself. So those would be good examples of places where age of a party may be relevant. Sidebar, please stop conveying property to minors. It's not something that we can always help if they inherit, but it is a pain in the butt if you've ever had to go get a guardian in order to deal with a piece of property because title is vested in a minor. You have clients who are trying to put title into their minor children. Please consult with them before you just draft that deed. It is a huge pain to have them do anything with the property after it's in the name or after it's vested into the minor. All right. More things we can do with an affidavit of title to land. We can give an affidavit whether the land embraced in any conveyance or any part of such land or right therein has been in the actual possession of a party or parties connected with the chain of title. The payment of debts of an unadministered estate. We talk about the fact or date of death of any person connected with such title, or where such affidavits relate to the identity of party whose names may be shown differently in the chain of title. So number 4, whether the land is embraced or conveyed in any part of such land, this may be a great place to give an affidavit of possession or use an affidavit of possession when you have a partial adverse possession case or a boundary line dispute that you're trying to establish that this property has always possessed up to, maybe you've got a river and we're trying to establish where the boundary is. If you can get an affidavit that says that we've always considered the boundary line to be the river or that fence that runs through the field, that's good evidence of where the parties intend that boundary line to be. And maybe they're adversely possessing up to, even though that's not what's vested on title. And then at that point, you call Susan and you say, hey, can I insure the property up to the fence, even though it's not vested? And she gives you her answer. I'm not going to put her on the spot. Number 5, we have the payment of debts of an unadministered estate. So if you have somebody who is deceased and you can have a statement saying they didn't have the debts. You know, they were somebody who always paid cash for everything. They didn't have credit cards or a mortgage or anything like that. And so we're going to convey the property free and clear without probate. That would be a good example of payment of debts. Number 6, the fact of death, date of death of any person connected to title. We already talked about joint tenants with right to survivorship. The other one I want to point out, and this is going to be in next week's title standard seminar, or I'm sorry, the title standard seminar 2 weeks from now, is the new transfer on death deeds. If y'all aren't familiar with them, you really should come to the seminar 2 weeks from now, where we talk about transfer on death deeds again and some updates on them. So transfer on death deeds become effective on the death of the party. So it's great to have information on record that that party has passed. We want to know that as a fact. We can also do an affidavit of title to land where it relates to the identity of a party. Married or divorced individuals who maybe have changed their name and maybe forgot to include that on the deed record. Great time to put an affidavit of title, cross-reference it to the vesting deed and say, you know, Jane Smith is now known as Jane Jones because she got divorced or she got married, and they're the same person. It's also useful if you have people who go by their middle names. I don't know what it is about the South, but a lot of people like going by their middle names. And so they'll sign something and it will be my partner, Scott Schulten, goes by Scott, but his first name is actually William. And so everybody just writes Scott Schulten and would assume that that is his name. But if you saw a document vested into William Schulten, all of a sudden you have a question. That same guy, Schulten's not really a common last name. So an affidavit of name would be a great thing to put on record saying these people are the same. And you can cross-reference to more than one deed. So you can maybe cross-reference to your vesting deed into William Schulten, and you cross-reference to your vesting deed out of Scott Schulten. Say these are the same parties, this conveyance. There is not a missing interest. All right. And then more uses for affidavits of title to land. Last two, number 8, where such affidavit shows the ownership or adverse possession of lands or other persons have not owned such lands or not been in possession of the same. Again, this gets back to adverse possession and affidavits of possession about what you have or have not possessed. And then number 9 is our catch-all, where such affidavits state any other fact or circumstance affecting title to land or to any right, title, interest, or lien or encumbrance upon land. This can cover any other matter, as long as it meets the other standards that we look for in an affidavit. So statements of fact within the applicant's knowledge, sworn. I've used it to recite statements about where the land lot line may be and whether or not my property is in more than one land lot. I've used them to recite that the tax parcel ID number changed. And so the tax lien may not attach or may attach based on tax parcel number changes. So you can use an affidavit of title to land for a wide variety of things. It's a great title. It's a great thing to do to kind of fill in your chain of title. If you've ever had that really painful chain of title where it took you hours and hours and hours to figure out what's going on, and you kind of put all those pieces together, maybe consider doing an affidavit of title that just recites your findings and cross-referencing it to the various deeds in your chain of title, especially if you have very complex descents. Maybe you have a complex interest where it's split into 132nd interests and then came back together, and now the parties are conveying 100% interest. That can be useful. And that way you can just put statements on record to guide other people through your findings. So you prevent questions down the road about, hey, how did you clear this title that you did 10 years ago? And you go, oh gosh, I remember that was difficult, but I don't have good notes about what I did when I looked at that chain of title 10 years ago. If you do an affidavit of title to land, you can put that on record so that everybody knows your conclusions as you did them, and you don't have to try to remember what you did. All right. Other parts of the statute, section B is reserved. That's all it says. And then section C says affidavits referred to in subsection A of the code shall be filed by the clerk of Superior Court. This is talking about recording where the land is located and shall contain a caption referencing the current owner. This is actually what's required by statute. It has to have a caption referencing the current owner. It has to have a deed or other recorded instrument in the chain of title as a cross-reference. And the clerk of Superior Court shall record such affidavit, shall enter on the deed or other recorded instrument so referenced to the book and page on which such affidavit be recorded. So the clerk should cross-reference your best of whatever deed you referenced back to your affidavit. And she'll index the same in the name of the purported owner, so whoever you said was the owner, and shall show such caption of the purported owner as both the grantor and the grantee in the index. In the deed records as conveyances of land are recorded and indexed. And the clerk shall be entitled to receive compensation for recording. So basically just the clerk is going to record it. They're going to cross-reference it to everything that you've told them to cross-reference it. And they should put it in the chain of title, which is why it's very important to make sure you're cross-referencing and listing the current owner so that it falls in your chain of title. and can actually be found in your title search. If for whatever reason you can't, it doesn't fall into your chain of title, maybe there's a break in the chain of title, and so you're trying to fill in that gap. Or maybe you have a dispute. I have one recently where we had a dispute about ownership and we wanted to file an affidavit because it was important to the facts of title. So we cross-referenced it, and cross-references are great tools for bringing something within the scope of your exam. Your examiner should be checking all of the cross-references on all of the documents in the chain of title. So if you cross-reference to a deed in the chain, it will bring your affidavit into the scope. And then some other uses for affidavits. So these are things that aren't necessarily covered by the title standards, but other times that I've used affidavits of title or an affidavit to do something on record. An affidavit to record a lost deed or documents that are not otherwise ineligible for recording. Again, this isn't necessarily something you can use to fix the fact that your deed didn't get recorded. Better practice is to go get it re-signed by the parties. But maybe this is an old deed and now your grantor is deceased. And you want to at least evidence that we think they intended to convey the property back in 1979. Again, talk to your underwriter about it. I see Susan over here looking, she's like, I don't know about that. But there are times where you're just trying to get some facts out there. It's not necessarily going to be conclusive, but it starts building some information that would be helpful. And maybe, again, it's a deed. We actually found the conveyance deed from 1979 that covers that gap in the chain of title. So we just want to put it of record to cover that gap, and our underwriters have already been insuring over that gap. So it's not creating a true new conveyance. You can also use it as evidence of an improper conveyance, an invalid foreclosure, or a notice of fraudulent conveyance. There's been some discussion on the listserv recently where sometimes a DUP got filed, and then it was found out after the DUP was filed that the borrower filed bankruptcy before the foreclosure sale was cried. And so that foreclosure is now invalid because it was never valid. And so we need to take that DUP off record. An affidavit to that effect can be used to help remove the deed from record. And I had one recently where we had a fraudulent conveyance where the grantor and the notary both got totally forged. Yeah, they never signed it. And so when we reached out to the party and said, hey, did you sign this? They went, no, I've never seen that document before in my life. I said, hey, could you sign an affidavit saying I didn't sign that? And we were able to put those on record, and that helped us clear title and get a declaratory judgment that the deed was forged and was void because it was a forged deed. Affidavits to correct errors in execution. This is actually allowed by statute. If you've ever had your security deed, or you go back afterwards after your borrowers have left the office and you notice, shoot, I forgot to sign page 7. You know, I forgot to sign my my closing attorney's affidavit, but I was there. I signed all the other pages. I know I did that. I did the closing. And go back and do an affidavit saying, I know I was witness there. The attorney did the closing and I should have signed their page. I'm now putting everyone on notice that that was properly witnessed. You can also do an affidavit of deed to secure debt regarding the maturity or its payoff. If you've ever paid off a security deed and then the lender just won't give you a cancellation, and you keep getting phone calls about, hey, is this still open? You can actually, as the closing attorney per statute, and that's 44-14-80C, you can file an affidavit of cancellation yourself after you've gone through certain steps. and it shows that you paid off that loan in full, you have to attach a copy, I think, closing statement, the payoff letter, proof that you actually paid it, so copy of the check or the wire reference. And then you're making a statement that I am the closing attorney, this was paid in full, the lender has been non-responsive, this should be canceled over. And then another use for affidavits, evidence of tolling of periods of time. So this would be really useful during COVID. Maybe we had a party who only had a certain amount of time to file a lawsuit and they were prevented from filing that suit in a normal, timely manner because the courts were closed because of COVID. That's technically a tolling of that time period. We have situations recently where due to weather, there have been states of emergency declared by the governor. Those technically could be tollings. So if you have something that tolls your statute of limitations and you want to preserve your party's right to file suit or continue their rights because we haven't had a full 4 years or whatever the statute of limitations is because it's been on hold due to tolling, an affidavit put on record saying, hey, during this time period, the statute of limitations was tolled and paused. So it hasn't been that requisite period of time, and this is still a good lien, even though it doesn't appear it on its face. That would be another great way to use that. And then I think we're all familiar with some off-record affidavits. These are common for title practice. We have sellers and owners title affidavits that we all use for closing, for issuing title insurance. I hope everyone's using it to issue title insurance. If you're not, please talk to your underwriter. Affidavits regarding brokers for commercial transactions. Brokers do have lien rights, and so you need to get an affidavit saying whether or not they have been paid and they have lien rights to the property. Sometimes you have same name or not me affidavits saying that, hey, there is, my name is John Smith. There are 20 liens against John Smith's in Fulton County. None of those are me. None of those liens attached to my property. And then sometimes you have surveyor's affidavits where the surveyor is giving an affidavit about property they survey that you can use. One note, same name, not me affidavits, they do not need to be recorded. Those can be completely off record and just kept in your file. Please don't record them. They do clog up the real estate records. And that is all I have. So thank you. Yes, you for being here at the Title Standards Seminar. And may you never have to deal with a sovereign citizen case or an affidavit of truthiness of any type in your chain of title. Thank you. We have 2 minutes. Are there any questions?
Just listening and up to the whole presentation and the use of the affidavit, it's a great tool, but it obviously always has to be approved by the underwriter in most cases for the purpose it's intended. Clear title or do something in the title.
It's merely a statement of fact. It does have evidentiary value, but it is not a substitute for, say, a deed of conveyance or an actual transfer.
Right.
It's just trying to get information. Anyone else? Thank you very much.
Okay, thank you, Ami. Next up, we have Patrick Hagler. Patrick serves as Senior Underwriting Counsel at First American Title Insurance Company, where we love having him as part of our team. And he is going to help us navigate through some different title issues today. Thank you, Patrick.
Good morning, everyone. My name is Patrick Hagler, as Susan said. I am with First American. I've been in Georgia now 21 years. I just realized that I moved here Super Bowl Sunday in 2005. I've been underwriting 19 of those years in Georgia. So I've been doing this a while. I I'm sure how I am sure how I ended up here, but it's odd. Like during college, I worked for a surveyor. So I've been on the surveying side. During law school, I clerked with a law firm that did real estate, and I just kind of got the bug and I stayed and got it hooked. When I graduated, that law firm stuck me in a title company and said, go learn how to abstract examine, learn it all, and I did. So I ended up here in Georgia, and I love what I do. I love this industry. There's something about being able to help people get into their first home or working with a complex commercial deal. It's just a lot of fun, and I've enjoyed it. I love what I do. I enjoy doing this. I love working with the young attorneys as well. I do a lot of that kind of teaching. Those people who have ever taken one of those classes that heard me speak, the first thing I tell them is, do you know what the title standards is? If anybody in here doesn't know what it is, let me know. When I moved here, that title standards I printed out. I had it flagged and highlighted and notes in the tab. I still keep it on my desktop today, and I refer to it often. Even though I use it all the time, I don't know it by heart. We know most of the rules and all that jazz, but keep it in there. So the title standard can be your friend. So we're going to hit some of the main issues that we see from the underwriting side. Something I am going to mention just here. So we've got what the law says and we've got what the title standards is. Then we have what we do on the underwriting side. Yeah, we still want to comply with the law and we want to do what's right. We want to keep the record clean. We want to keep legal descriptions clean. We want to make sure everything's tied up in a nice little bow. Sometimes that's not realistic. So what we look at from our end is what is the risk factor involved if we insure title. It never fails when I speak at one of these things, I'll have an email when I get back that says, oh, Patrick, but you said, sometimes we're going to vary from what is exactly the law here just because our risk is low. Like if we know there's a situation like what Amy was talking about, that we can tie together with an affidavit that gives us a comfort level that we're not going to have a claim, we're probably going to vary from what the exact law may be. We're still going to be as close as we can, but we may say, okay, you know what, our risk is low. And we'll talk about that a little bit in divorces of where we're like, okay, we're probably good here. So we'll go down through all of those kind of step by step. Please, if you have a question, feel free to interrupt and ask. I'm happy to pause and answer your questions. The first thing we're going to start with is divorce. We get a lot of questions about divorce. So what the title standards say and what the code says is we need a final decree of divorce in order to insure title. Yes and no. Really, when we started kind of bending that requirement was during COVID. When the courts were closed, people couldn't get in. We're having to do things a little differently. But what we look at in every case, the reason we're concerned about it, there's a standing order filed in every county when you file divorce, essentially saying that you cannot do anything. You can't convey property, you can't move money from your bank accounts, you can't do anything with your assets. The court's protecting the assets of both husband and wife so that they can be protected during the process. So that's what stops us from being able to close an insured title is that standing order. So what we look at is what's the situation with that divorce? Who's involved? Are they represented? And what's going on there? So the first thing we're going to look at and ask for is there a final decree? If not, look and see if there's a settlement statement. And you may say, yeah, there's a settlement statement, send it to us. And we'll look at that and see. We're going to look to see if the parties are represented. We want to look and see if they're splitting money 50-50, what the situation is. Is there any risk if somebody got the upper hand over the other party? So if you've got a husband and wife come in, the wife's not represented, the husband is, we're probably going to look at that a little more closely and say, they need to get a final decree. That's just the kind of things we're going to look at in there. If they're not represented, neither party, reach out to your underwriter. Ask them, tell them what the scenario is. If it's one of those scenarios, it's very amicable. They're gonna come in together, they're gonna sign, they're gonna split proceeds 50-50. We're probably gonna say, okay, that's good. We'll insure over that. So we just kind of look, if anything gives you spidey senses that doesn't feel right, it's probably not right. So reach out to us, talk to somebody in your law firm, just get an idea of whether or not there's something shady going on. Where we always see it, never fails, probate, divorce. There's some stuff that can happen in there and people trying to cut each other out of property, out of money, whatever the case may be. If you do have a final decree of divorce, all you basically do is follow those terms. If the divorce says, wife gets the property, we'll pick up a quitclaim deed, just follow the terms. If it says the property needs to be sold and they'll split 50-50, or wife gets first 65,000 and then they split 50-50, whatever it says in that divorce decree, that is your closing instructions, basically. Any questions on that? Another question we get quite often is, yes, sir.
What if they got divorced 2 years ago and they've decided they don't want to sell it? The husband's just stayed living in it. And now the wife just wants a buyout, but it doesn't comply with the decree.
Well, basically, we'll look at that as well and kind of weigh out the facts and what the risk is there. I mean, if it's something that is extremely detailed, we're probably going to say they need to go ahead and get an amended order. It just kind of depends on the facts of how detailed it was set out. I mean, a lot of times you'll see in there that the wife is to refinance within 60 days of the divorce and it never happens. Let's say she refinances 6 months later, a year later, we're probably like, okay, yeah, fine, that's no big deal. But if they're making substantial changes to what the divorce decree says, we're going to say, let's get an amended order. I mean, it's case by case. It never, these things never end up being exactly the same. So the other thing we get quite often is questions about on your seller information sheet, it asks whether or not they've been divorced. And they say, yeah, I was divorced in 2019. They didn't buy the house until last year. We don't really care about the divorce. That was well before they purchased, no big deal. As long as it's after the divorce, it does not involve us at all. So we're not going to worry about that. The only time we might look at that is if they bought it the month before the divorce and there's no mention of it in the divorce decree. We might say, hey, this doesn't look quite right. Any other questions on divorce? I know this is a lot, y'all, and I'm probably talking way too quick, but like cover. In the title standards, divorce is in chapter 27. There's a really good breakdown in there for that. The thing I do love about the title standards, when you're looking at a particular issue, it's a great springboard to get you into the code if you need to dig deeper into what happens. The other thing that we do with the title standards, anytime there's a substantial change every year at the meeting of the state bar at ICLE, we update the title standards. So it's going to be the most current out there. Just make sure you have the most updated version. The current one's 2024. So just keep that in mind, but it is the most updated. Powers of attorney, we're getting this more and more. We're also getting more conservative about what we accept and don't accept, just because of all the fraud that's going on out there right now. We do prefer a specific power of attorney that is specific to your transaction. Always the preference. We will accept a durable power of attorney when they're being used for the purpose they were meant for. If somebody has fallen into any kind of mental disability, physical disability that keeps them from handling their financial affairs, we will look at that. The thing that I always tell people, especially if you're dealing with somebody with a mental incapacity, get a doctor's letter, get a letter from the facility they're in, because what that's going to do for you when you call the day of closing to do a live and well check, You don't have to do the well check. You just need to make sure that they are still living the day of closing. They can't confirm the transaction. They don't have the mental capacity to do so. So get that doctor's letter. That's protection for you, protection for us. Also kind of identify who the heirs are. Who's going to be affected by this power of attorney? Does it look like one child's being cut out of mom's estate somehow using the power of attorney? Make sure, we look at self-dealing as power of attorney being used to convey the property to themselves, all that stuff. So we just look at all of that. But if you can get a specific power of attorney, that's the preference. You can get a power of attorney for fiduciary duty. Personally, I'm not a fan. I think if you can't do your fiduciary duty, you need to get somebody else appointed to do it. But it is acceptable. The power of attorney has got to be executed though in that capacity. So if they are a administrator, they need to convey POA as administrator, same if it's a trust. When you're looking at trust and that kind of thing, you've got to check and make sure that the trust actually allows for a POA to even be used. Most of your standard trusts do have the language that allows for that, so just be cautious of that as well.
I did have a situation once where there was a financial power of attorney and a durable power of attorney for a soldier who was deployed.
Yeah.
And it was used to purchase a property while they were deployed, which should have raised a red flag. And when they got back 2 years later, they were very upset that all of their money had been used for their boyfriend to buy a house in their name and live in that house for 2 years without their permission.
Oh, yeah, it happens. I mean, more often than you think. Any questions on powers of attorney? Once, twice. Name variations is another one we see quite often. We look at these as well. Again, it's things like as the attorneys and the examiners and abstractors were stewards of the record, as I said. So we want to keep it as clean as we can and make sure that everything is matching up. But occasionally there's going to be those obvious name variations that we're probably going to look at, and we're gonna probably ensure depending on what the situation is. Name variations are in chapter 3 of the title standards. So what we see quite often is initials, like this one says BJ Gamble, but it conveys out as Billy Joe. We're probably gonna say, okay, look, that's close enough, y'all. We're gonna look at the facts around it, look at the title around it, see how he signed his name, and go from that aspect of what's on the record that we can do to get comfortable. One of the things I always tell people to really watch out for though is the junior and senior. So if you're looking at the title and it either drops the name off or they're just swapping them back and forth. Something that all invariably happens is when senior dies, we may have a junior becomes senior, and that it gets very convoluted in the record. So just be cautious of that when you're looking at those names. If you've got a Kelly that's spelled with an I instead of a Y, we're probably gonna say, okay, we're good. Like we're gonna insure it. If it's in the back chain, like if it's your current people, we're gonna figure that out. Corporations are a little trickier. I'll just mention those here because of the name itself. When you look at Secretary of State, if it's like a flip-flop letter, maybe if it is Patrick Hagler Properties, Patrick Hagler Development, those don't quite match up. So we're going to require corrective action. And I'll get into that a little more when we hit corporations. Okay, probate. This is probably one of the areas besides divorce that we get the most questions of as underwriters. The title standards in chapter 13 lays this out step by step. It's fantastic. It basically says person died within 3 years. This is what you do. 3 to 6 months, 6 to 12 months. It just lays it out step by step. Whether or not you've got an administrator, executor, testate, intestate, it tells you exactly what to do in the title standards, and it links you back to the code. So it's a great spot to go and look at any of this up. If the death has been within 3 years, the code says that you have got to go through probate. Amy mentioned the affidavits of heirship earlier. Those are available for some situations after 3 years. But if it's before 3 years, then we're gonna require they go through probate. This is something that comes up all the time. If there is a will and they come into you and say, we have a will for this property, you cannot use an affidavit of descent. If you know there's a will, it's gotta be probated. So they're gonna have to go down and file the probate. Because that person who died left instructions of what they wanted to happen and we need to follow what they want. That's essentially what that is. And if you want to look that up, if anybody pushes back on you, it is in code section 53-5-5. Okay, so where we have an executor appointed and the will grants the power of sale, and there's no specific devise of real estate, the executor can convey. We don't need anything else. So, but if we've got a power of sale and there are specific devise of real estate, we're gonna want to pick up deeds from those heirs. So if daddy dies and leaves it to mama and 2 kids, we're gonna require deeds from all 3 of them and the executor of the estate. If there is just a general devise of I leave everything I own to mom and the 2 kids, we're good. We're gonna take a deed out of the executor of the estate. No problem there. If there is no power of sale contained in the will, they're gonna have to go and get a separate order of sale. They just petition the court and get the power of sale. What happens both with these, and this is something I always watch for, both on the getting a letters testamentary or letters of administration, especially on the letters of administration, where you've got the laundry list of things the judge signs and checks, always make sure that they did grant the powers. When those powers aren't granted, there's typically a reason. The court wasn't comfortable with them selling without court overseeing the transaction. So just make sure you pay attention to those boxes that are checked. And on letters of, on the letters when they're appointing the executor, a lot of times the judge isn't even looking at the will necessarily. They miss quite often when there's not a power of sale, and they'll issue those letters, no problem. When we go and look at it, they don't have power to sell and they've got to go back in and get that supplemental order. Any questions? I know that's a lot. Yeah.
Would it be a good idea to add something in the affidavit stating that there's no known will or a separate affidavit attesting to that?
Yeah, and I think I think the standard affidavit may say that. Do you know? I think it does say that there was no will. There's a statutory affidavit that I'll double check it when I get done up here. Anybody else? Okay, so if we've got a intestate estate, so we have no will, we're gonna look at, like I said, we're gonna look at the powers granted. We're gonna make sure that they got the powers granted under 53-12-261. That's the first check mark on that, the letters that are issued. I think it's number 8. So we're gonna watch for that. If the state is intestate and it has been more than 3 years since the death, that's where we're gonna accept the affidavits of descent from disinterested parties. We'll check back on her affidavit in a minute. And quitclaim deeds from all the heirs. So what Amy would say it to you about, most of the time you are gonna have somebody related to the heirs because that's who knows the family history. We usually say, look, ask, do they have a pastor? Is there a family friend? Is there a next door neighbor? Is there somebody in the family who's not gonna inherit this property? Say their Aunt Susie over here, could she sign? We prefer that. Sometimes the odds are that is not gonna happen. Just communicate with your underwriter. Ask them, hey, could we do this? Will this work? This is the family situation. We've got mom's will is probated over here. We know the family history. It's already been probated. We know everything's there. Can we do an affidavit? We're probably gonna say, yeah, that's fine. This is what mom and dad wanted in the long run anyway. We do have them, in estate situations, everybody has them sign the affidavit of taxes and all that information. We just want to make sure that's there. We want to verify any creditors' claims against the estate, if they've been paid or not paid. When we look at those creditors' claims as well, what we're going to look at is where's the money going? If we've got a transaction where the estate's selling, all the funds are going back to the estate, that's the executor's problem. They need to deal with those creditors' claims. That's completely separate than any other liens of title, security deeds, 5-phase, water bills, any of that. That we're not going to insure over. This is a separate thing. It's a creditor's claim filed against the estate itself. So just watch for those. And if you have something, reach out to your underwriter, ask them what to do if you don't know. I say this all the time, folks. The only stupid question is the one you don't ask. Just ask your underwriter if you think that's an issue. If you, like I said, spidey senses go off, ask your underwriter. That's literally what they pay us to do. So we are always happy to help you. Any questions on probate?
What happens if you have a situation where the executor has power of sale, was granted that, but one of the parties, who was a beneficiary, a named beneficiary, refuses to sign a quitclaim? Maybe they just have a personal attachment to the property.
Yeah.
They want what mama promised them.
We do see that from time to time, and essentially they're gonna have to go back into court, and the court can basically order them to sign, or they can just issue a directive saying that the property is hereby vested in kind of thing. I mean, there's really not much way around that, but it would be handled through the probate court. Good question. We see that quite often. And it's the same scenario, guys. I have an email this morning about a scenario where there's 7 kids. They can only find 6 of them. What do we do? Do we need all of them? Well, yeah. If the person who asked the questions on the seminar, sorry. But yeah, you need to pick up all of them. And again, you would work with the probate court, see if we can get some kind of order allowing for the transfer without picking up that interest. May or may not happen. I mean, probably not. There's ways around it. They'll just have to work with probate court. And usually our advice when we get those questions is they need to go consult a probate attorney. Man, we get lots of questions, guys. And if you've ever reached out to your underwriter and they're like, they give you a vague answer, it's because we're not in a position that we can give the advice that you're asking. And we'll tell you, like, you know, we can't really give an illegal opinion on that. We can give an opinion on what we're comfortable insuring, but as far as giving a straight out legal opinion on something, we stray away from that. As I'm speaking about my legal opinion. Okay, legal description. I mentioned this when I first started speaking. We want to keep the record as clean as we can. We know that's not always possible with things that have happened in the back chain, and sometimes there's not a way to correct that. I reviewed a file yesterday that was, the legal has been wrong for 49 years, I think it was. I mean, and there's really no way to fix that, but the record, if you look through it, it's quite obvious that it was the right legal. So we just kind of worked around, backed into that, and I got comfortable to ensure. It wasn't perfect, but we got comfortable there. Where we've got a short legal, which is your non-meets and bounds, where we've got a platted property and a subdivision. When we're looking at the legal descriptions and there's mistakes in that legal description, we're going to look at to make sure the lot number is correct and the plat number is correct. The rest of it, we can probably work with you if it is correct on the plat. If we've got an off deed, say the district's incorrect, the section's incorrect, we're gonna go ahead and say correct it going forward with a derivative clause back to the correct deed. That saves you from having to go and get a corrective deed. If it's possible, you know, if it's your vesting deed and it was just done a couple of days ago, we're probably gonna say fix it. If it's something that's been on the record for a while, we're gonna go ahead and say, we'll ensure going forward. This happens time and time again. Guys, the most important thing to do with legals, whoever is reviewing that, review it 3 times. Like, once the examiner sends it, have somebody review it, whoever types it in, inputs it, you know, now I know it's coming over in a Word format, so you're not having that initial type is putting in there. But that's where the biggest mistakes are made on every transaction that we review is in the legal descriptions. And what happens down the road is ends up costing somebody a lot of money because they're gonna have to go out and get a survey and get it fixed. So the best thing we could do is deal with it when we see it and find it. And we do try to correct it from our end if we can. But like a simple thing like that, where it's just a phase or a district, we're gonna go ahead and correct that going forward. One of the caveats there to look at is if there's multiple phases in the same subdivision, be cautious of that. Because if we've got lot 2 and the plats are all in one large reference number, so you've got phase 1, phase 2, phase 3, and it starts with the same plat number and everybody's referencing that original plat number, we're going to be cautious of that, because if there is a lot 2 and phase 1 and phase 2 and phase 3, we don't know which phase that lot came out of. So we're going to look at that. The other thing we're going to look at is also the record of chain of title from grantor to grantee to see where it flows. And if it's the same property, we're going to be able to work around that as well. We get a ton of condo questions. So all that is required for a valid condo legal is a reference to the unit number, and as more fully described in the declaration of condominiums for whoever and in the deed book page. It should have the plat, floor plans, common elements, and all of that in it, but they are not absolutely necessary, and we would let you fix that going forward. I probably get that question 3 or 4 times a day. Yeah, it should be there. It's not catastrophic, and we're going to agree to ensure going forward. Okay, here's another big one. I forgot about this one. Do not include parking lot spaces, storage unit numbers, any of that on your legal. They do not belong there. Those are typically covered in your decks, and they convey as part of the conveyance already. So just read that and you'll see, but they typically do not belong there. And what happens is if you say this person's got parking lot 242, that may not be their parking spot because it's assigned when they purchase. So what the prior owner had parking spot 242, they may get 252. So it just doesn't belong there, because then they're going to come back to us to be like, well, I don't have the parking spot I thought. I was closer to the elevator, you know, whatever it might be. So just watch that. Same with storage units, it's going to change. Pay attention to the subdivision plats. Make sure that there is sufficient information to locate the property to be insured. Lot lines, lot dimensions, point of beginning, any of that stuff that you typically see when you're reading a meets and bounds description. Make sure you got everything that you can actually find the property. If I was going to go look and see if I could drive over and find this property or find it online, would I be able to find it with the legal that's of record? And that's basically what we're looking at there. There's tons of horrible legals out there that just have been messed up through the years. People like to play attorney all the time and it ends up just a mess in the record. We try really hard to work with everyone and not require surveys and not cause expense if it's not necessary. Sometimes there's just no way around it. And I will tell you, if your underwriter is saying we need a survey, it's bad because we've been, another pet peeve of mine, but we've been not requiring surveys in Georgia for platted property, and a lot of, if there's platted record, if there's survey of record, we're gonna do a no change affidavit and insure it. So if they're saying there's a survey, there's a reason. We're not just saying, no, just do a survey. I don't wanna mess with it. There's a reason that we're requiring a survey. Questions?
Have one.
Yeah.
So, my builder loves to, change lot lines on me. And it's a neighborhood, big neighborhood. And so, my title company loves to use the old plat. So I always check it and we always tell them, use the most current, revised plat number. So then they'll go and they'll put original plat as revised in with, like, they literally just filed one that changed the lot lines of multiple lots. So do you all want us just to use the last, like, plat, the most recent plat, or do you like where it was, the lot was smaller originally, then they revised the plat and now it's updated and they put that as revised as?
Right.
No, I never know the answer to that.
I think it's gonna depend on the circumstances again. If it's affecting your particular lot,
What we're
Well,
doing the whole neighborhood.
well, right, but if, say, in some of those, when the subdivision plat's done, like they move everything over
Mhm.
2 feet. Sometimes they take 3 lots and combine them into 2. So it depends on if it affects it. So
Okay.
if your property was not changed,
Mhm.
you just kind of follow the plat. My personal recommendation is I'd say original as amended, as long as it goes on, just because it ties the history of the property
Okay.
together. So I would go ahead and include it.
Okay, all right, thanks.
Okay, LLCs, authority, all of this fun stuff. I'm gonna start with LLCs just because that's where we get the majority of our questions. Every investor pretty much is an LLC. Some are set up right, some aren't. But when we've got an LLC that comes in, the first thing that you're gonna get asked for from your underwriter is gonna be, do they have an operating agreement? Do we have, any direction of who's got the authority to close the transaction? All of these investors, for the most part, I won't say all, do not want to have an operating agreement or just don't set one up. They create a business, get it approved with Secretary of State, so we've got articles of organization, but then they don't take the next step and have an operating agreement. Pet peeve, but we can't really do anything about it. But the only time we're gonna accept that without an operating pretty much is if you've got a very simple single member LLC, maybe a double member LLC, because otherwise we're gonna wanna know who's got the right to sign. We can Band-Aid it with resolutions and a consent and all that. It's just not the way that they should be doing business or that we want to insure it really. But if we can get to a comfort level without them having an operating agreement, we're going to try to get there to help you. If not, we're going to say, no, they need to have an operating agreement. It's like all the time. I would say probably this is probably corporation questions coming as much as divorce and any of these others. I mean, we get this quite a bit. I think it's the nature of what the industry is right now with all the investors and all that happening. And also people buying houses, they're trying to protect themselves from any kind of creditors or that kind of thing. So we are seeing more and more people put their properties in corporations and trusts. So if they do have a operating agreement, we're going to review that for authority. If it does give a member the authority within that operating agreement, we don't need anything else. If it is a member managed company, we're gonna go ahead and get a resolution or a consent allowing Patrick to sign on behalf of the company or allowing Susan to sign on behalf of the company. If there's 3 members, we'll get them all 3 to sign, give one the permission to sign. That's only if it's not set forth in that operating agreement. The operating agreement says Patrick can sign, you don't need anything else, you can go move forward all day long. We're gonna hit the MIA at the very end, but some of the back chain issues with authority are covered by the MIA if your seller's got a prior owner's policy. Does everybody know what the mutual indemnity agreement is? Anybody? Okay. So, if there's a missing capacity, like it's got the signature, it's got everything there, but they don't say what the capacity is, it's missing, he's president or he's managing member or whatever. That's gonna be covered by the MIA. If it's missing a corporate seal, that's gonna be covered as well. So there's certain things to use that will, and I will hit those at the end. Just some easy uses for the MIA if it is available. When you're dealing with trust, look at the trust code. We're gonna review the trust agreement for who has the authority to sign on behalf of the trust. The code does allow us in Georgia to rely on a certificate of trust. So if that's all that's presented to you, send that over to your underwriter and have them review it for you as well and whether or not they're okay to accept it. But typically it's fine. As long as that certificate is still valid and nothing has changed, we're gonna take that just like it was a copy of the trust itself. That certificate says who has the authority to convey, and basically that covers our authority issues. If your seller acquired from a trust and the trust is not of record, again, ask for an owner's policy or prior attorney and ask for authority. What I get this quite often on the whether or not to record the trust certificate. Yes, record that trust certificate as an exhibit every time. On their certificate, there should be no personal information on there really other than their name. It's not gonna have social, it's not gonna have phone numbers, none of that's on there, so it's okay to record it. It should all be public record. So if you've got it, record it. I wouldn't record the entire trust agreement because that's got more information in it. But if you have a certificate of trust, record it. What that does for you down the road, you won't get the question of whether or not you have authority. So the more you can put of record to protect the record, but it also avoids people contacting you down the road and asking, hey, can you get this one? If it's already put out there, you don't have to go pull your file 10 years later and be like, yeah, I do this. So the more you put of record, the better when it comes to that. What else do we have here? Yeah, always for any corporation, LLC, any of those folks, make sure you pull the Secretary of State, confirm they're still in good standing, dues are paid, all of that. If it's a foreign entity, you've got a good check in Delaware or Nevada or wherever they formed their corporation at, make sure they're in good standing. They do not have to have a filed foreign status in Georgia to own real estate. We just need to confirm that it is current, active in whatever state they're registered in. Limited partnerships, you're going to get the partnership agreement. Again, we're going to read that for authority. We're looking to see who has the right and authority to bind the company. Typically, that's going to be the general partner. If there is, for some reason, he's not available to sign, that partnership agreement will instruct us who can sign or what the steps they need to take to get somebody the authority. Typically, they're going to do a resolution and have somebody else sign. Okay. This is always fun. We just had an argument about this on an email yesterday. So the acknowledgements we should now all be doing. It's been a law for over 10 years and people are still not getting it right. So we'll figure that out eventually. So what you see there is the requirements to a juror in Georgia. That is the proper jurat, signed, sealed, delivered in the presence of. We see all day long variations of this. The most important thing that we're looking at is in the presence of. If that is within, if they've added a paragraph this big, if that's in there and we see in the presence of, we're probably gonna accept it. The only thing that's through the old acknowledgement form that we used to have, the one you see in California that they send every time, even though we send them the Hancock acknowledgement, that's the one we don't like because it's not valid for recording in Georgia. So yesterday we had an issue with a power of attorney that was not properly acknowledged, jurat, whatever. So we're going back and forth about that, and I accepted it, but it was more of, they were arguing the fact of whether or not the code actually applies to all recordable documents or just the deed or the security deed. And at the end of the day, I'm not speaking for First American, I'm speaking for Patrick Hagler. At the end of the day, if it's, let me go back, where did you go? At the end of the day, on the power of attorney or something like that, our risk is not as great as, say, the deed, the security deed. And the change in this, the acknowledgement in 2015 was because of the security deeds and them being overturned by the bankruptcy court. So that was another level of protection to make sure that we had it signed in the presence of, there was no way around it, there was no fraud involved, that whole thing. So that was the change, but at the end of the day, if it's power of attorney, we're probably gonna say it's okay, let's record it as an exhibit to the deed. So there's no chance it's gonna get kicked back. Because it truly varies from county to county and how strict they are about reviewing those documents. So if a power of attorney comes through there and it is not in the proper format, it may get kicked back, then you have a problem. Excuse me, so that's gonna be my advice, have that as an exhibit. Get it a record that way, then you don't take the chance of it getting kicked back. If your deeds, your security deed, any documents like that do not have the proper jurat, we're gonna say get it fixed, get it corrected. If it's in the back chain, send us, if you've got an owner's title policy, reach out, get the owner's title policy. Let's see if we can cover it under the MIA or get a letter of indemnity from the other company. So there's ways for us to kind of fix and work with it. The other thing that has come up in recent years, when this is done incorrectly, if we can get a notary affidavit, basically the notary saying, hey, this is in my notary book. They were in here in my office, signed in my presence at this date, time, whatever. We'll go ahead and accept that, get that of record. It's a Band-Aid, y'all. We don't really want to do that, but there are some cases where we just can't fix that. Like say the seller conveyed out, died 2 months later, we're 2 years down the road. We're going to try to find a way to fix it and not cause a lot of trouble for whoever the seller is. So our job really, guys, if you haven't figured out, is to work with y'all. We want to get you to the closing table. We're not trying to prevent you from getting there. Unsatisfied liens, security deeds, HELOCs, all of this. The easiest and quickest way to clear prior security deeds is using the MIA. So if you've got a security deed from prior closing that pops up, reach out to that prior closing firm, ask your seller, do you have an owner's title policy? Most of the attorneys in town are going to be happy to assist you and provide you with an OTP if you ask for it. And when you reach out and ask for it, what I recommend doing is saying, hey, do you have a copy of the OTP or proof of payment? Most people are going to send it to you, saves us all a lot of time. If they've got an OTP that's over a year old, it's going to be covered by the mutual indemnity agreement. You're going to see it sometimes come in and ask, when we get the policy, we're going to require a letter of indemnity. It's usually because it's maybe 3 months old, 9 months old. So as long as it's over a year, we're gonna go ahead and say it's covered. HELOCs are not covered under the mutual indemnity. So we're gonna need a letter of indemnity on HELOCs if they pop up as a prior open one. Again, we're gonna look at those, we're gonna look at those and just kind of see what the risk is there. Some of these open loans are 45 years old. I looked at one the other day, it was a Taylor Bean and Whitaker from way back when. I agreed to insure over just because I knew there was no odds of that coming back. The other thing you can check on these prior open security deeds, if you check the MERS website, if it's got a MERS number, you can look in there. If it shows inactive in MERS, that's just another level of comfort to get to say, okay, MERS is saying this is inactive and it has been for 10 years. That's going to get us some comfort level as well. If there are prior liens in the name of the current owner, obviously you're going to reach out to your underwriter and get those cleared. If you have a cancellation in hand or you have an email from the lender saying that the release is going to be filed, reach out. We're going to agree to insure pending that release. If we've got a comfort level it's coming, we're going to go ahead and say close and we'll wait for it to come in. Okay, liens against buyers. I get this question all the time too. You still, for the most part, the lender's going to want you to run the buyer's names primarily to see what's out there. If they have a ton of liens up there, they may be looking at that for their debt loan ratio and all that stuff. So that's why we still run them. But any buyer's liens, including IRS liens, is subordinate to the purchase money security deed. So as long as you know, and you'll have your instructions that it's purchase money security deed, buyer's liens, we can insure over. They're not going to attach until they get in that house. If it's any other kind of loan, besides purchase money, refinance, anything like that, we've got to pay those off and pick those up. Questions?
What are your thoughts on lien sweeper?
Again,
What are your thoughts on lien sweeper? I was just referred to use that for like an old security deed. Haven't gotten it back yet.
Is that like- like required.
Yeah.
Yeah. I mean, they do a good job of searching this down. I don't know that I've worked with them directly. I used to work with a company a lot that did that for us. But they can, basically you pay them a certain fee and they take care of it for you, so you don't have to hunt it down. I mean, it works. It just depends on, for a long time, this has always been an issue in Georgia, people not releasing liens, so it's just out there forever. So the company I worked with did just that, and it was a fee that was passed through to the seller to get their lien release, because it is technically their responsibility. Okay, 5-phase. Expires 7 years after recording unless renewed. So if it's over 7 years, we're going to insure over. If it's not, if they have filed a nulla bono and continue to do so, as long as they keep filing that nulla bono to renew and extend, it's got to be paid off. If they miss that period to file or don't file, we're good to insure over. Tax by phase. I get this question a lot too. So your seller owns like 5 properties throughout Atlanta. He's got 5 phase against a couple of them that are a different property than the one you're insuring. Technically, according to Georgia code, those attach to everything the people own. We're going to insure over those 90% of the time, because it's not going to, the tax commissioners typically not going to go foreclose on another property for taxes. It just doesn't happen. So the risk is low there. That's where we will, one of those things where we bend a little bit and we're good to insure. IRS liens expire on the date on the face of the lien. So look at that. It's typically for 10 years, 10 years from the assessment date. So it may be different. So your filing date and the assessment date and expiration date may be different. If you've seen some of those IRS liens that have like a stack where somebody hasn't paid for years, you'll see the release date is different from each of those years. So just be cautious of that and watch the date for release because each part is different. So you may have one that is expired and another one that's still active. Just make sure you catch every date that they are all expired. We get a lot of releases and cancellations filed in the wrong county, or it may be one of those properties that overlaps two counties. If it gets filed in the wrong county, what we recommend you do is get a certified copy, file it over in the county it belongs in. That at least gets it over in the right county and will ensure. Material liens, we're getting more and more of this again lately. I think construction's going again, which is good. They expire 395 days after the filing of the lien. So we're going to look at that. The code says a year. We're going to add 30 days to that and we'll insure. Attorney's liens, reach out to your underwriter and just ask. They all have a varying different expiration date depending on what the lien was filed for. And there's some nuances to those attorney liens and they'll be able to help you out with those. Doctor's liens, hospital liens don't attach to the defendant's property unless that debt has been reduced to a FIFA. So you'll see all the hospital liens, doctor's liens just filed randomly unless there has been a lawsuit filed and a judgment obtained reduced to a FIFA, they don't attach. So we don't have to worry about those. HOA liens expire after 4 years and we can insure Albert. I guess we'll talk about bankruptcy a little bit too. So we do get a lot of questions on bankruptcy. The biggest thing is whether or not you need to worry about the bankruptcy. If there is a discharge or a dismissal that shows up on Pacer, we don't care. It's in the past, we're over it. The only time you may need to dig into the bankruptcy is if there are some FIFAs or security deeds, anything that you might be trying to rule out. That may be within the bankruptcy code. So if notice was given to some of those creditors that have FIFAs, probably was wiped out by bankruptcy. So that's where you're going to be looking for things within the bankruptcy order. Yeah, FIFAs recorded prior, they're wiped out. So you're just going to look at that, look at the discharge date. When you're dealing with chapter 13 and any of those, chapter 11s, reach out to your underwriter, work with us, and we'll figure out a plan. You're probably going to have to get, if they're in one of the chapter 13s, chapter 11, even chapter 7, if it's pending, you're probably going to have to get an order to sell the property. Same bankruptcy, it's very similar to divorce. As soon as you file bankruptcy, there's an order of stay within the bankruptcy court where you can't buy, sell, do anything with any of your property. So that's what we're looking at mainly with bankruptcy to see if that automatic stay has been lifted or the case has been dismissed. So anything with bankruptcy, reach out. If you don't deal with it that often, it's very complicated. You can email me and I'm going to reach out to somebody who knows more about it than I do. But it is, and for what we do in real estate, it's not that difficult to learn, but when you get into Pacer and start digging, you can get lost very quickly. So if you need help, feel free to reach out. We're happy to walk you through it if we can. Here is the MIA, Mutual Indemnity Agreement. I will say check closely too and ask your underwriter about different companies. If it's a company you don't recognize, reach out and make sure they're a member of the Mutual Indemnity Agreement. There are a few companies that are not. This was originally signed years ago. It predates me, so it's been around a while. But this can truly be your friend as well as the title standards. Essentially, if you've got a prior owner's policy for your current seller that's over a year old, You can rule out unsatisfied judgments, federal tax liens, state tax liens, and real estate taxes and FIPAs are not covered, but you can rule out the others. Security deeds under $1 million. The absence of corporate seal we covered earlier. Absence of a notary seal in the chain of titles covered. So it really does rule out a lot of things that will save you time when you're trying to clear title. I got about 4 minutes. Any questions? Ooh, I went through that. And sorry, y'all, I've been in Texas all this past week and the cedar hit me, so I made it without like falling apart. Once, twice. All right, thank you guys very much.
Thank you, Patrick. Here today is Matt Mashburn. I think we all know and love Matt from his Mashie Awards, from his annual presentation at RPLI, which I think is coming up on its 10th anniversary this year, right? Yeah. Matt is a recipient of the Pindar Award, and he is going to lead us today in a discussion about the recent Ground Floor Holdings case and its impact on the title standards. So Matt, thank you so much.
Thank you. Hello, friends. Okay, so we've got the camera going, right? So I've got to stay. I can't move around like I normally do. Okay, well, welcome. Here we go. The Ground Floor Holdings decision and what it did to y'all. Click on down. Okay, so on September 15th, 2025, the sun rose in the east and set in the west. The birds chirped, the honeybees hopped from flower to flower. The rabbit slept comfortably in his hutch. Bear slept comfortably in her den. All was well and right with the world.
Mm-hmm.
And the title standard 2.2 said, in examining a title, the examiner is required to search only for properly indexed and recorded instruments in the chain of title. Sun set and rose the next day to chaos. That was the day that the Ground Floor Holdings Supreme Court denied cert and your life changed. Because now the law is, we're in a world where each and every misindexed deed is its own jury question as to whether or not the title examiner should have found it. No gasps. I was expecting gasps there because everybody fainted. So no, okay. Okay, so this is Mashburn's commentary. All right, so let's look at Title Standard 2.2 and just for sake of clarity and my own credibility with you, reprise the entire title standard, but we're only really interested in the first sentence, which says, in examining title, the title examiner is required to search only for properly indexed and recorded instruments in the chain of title, which is what I just read to you a minute ago, but I read it to you again so you could think about it more. Okay, so we're interested in that, and that's the Georgia Title Standard 2.2. So the first sentence tries to answer the question, to what extent should a title examiner locate a document outside the chain of title? Because if it's misindexed, it's not in the chain of title. And so I'm not going to read it a third time, but there it is again, just for sake of repetition. The marketing people say you're supposed to say it 7 times, but we're not going to do that. But we'll repeat what the highlights of that sentence are. It's got to be properly indexed. Before you're responsible for it, it's got to be properly indexed. It's got to be recorded, and it's got to be in the chain of title. So the title examiner relies on those 3 things being true before you can be hung on that document. Okay. So where did these title standards come from? So in preparation of this speech, I went back and looked, and our title standards say they come from the title standards, the model title standards from 1960. And it was a professor at University of Michigan Law School, Professor Symes, and he published these model title standards. And our title standards come from those title standards. And it was very hard to find a copy of the original model title standards. They're not anywhere on the internet that I could find. You can't buy them from Amazon. So it's just, there was nowhere to find them. But I contacted the University of Michigan Law School and I said, y'all are the keepers of the flame. This is y'all's doing. So y'all already have a record of it. And they did it. They had their original copy of the model title standards, and a librarian at the University of Michigan Law School was kind enough to send it to me. So yay. So go blue for all you Wolverines out there. Thank you. So credit to the University of Michigan Law School. And interestingly, it was not 2.2, but it was 3.2. And it said, in examining a title, sounds familiar, the examiner is required to search only for recorded instruments in the chain of title. That first sentence is different. So what was the difference? What did Georgia do to the model title standard what did the Georgia bar do? What did the Georgia real estate lawyers do when they wanted to pass? Oh, that's me up in the right-hand corner that you did that. Those are my thoughts. That's me thinking. In the top right-hand corner there. So, but Georgia added the requirement for a title examiner to be hung on a document. It has to be properly indexed. So the Georgia lawyers went the extra step of requiring that document to be properly indexed. So you can kind of see where we're going with ground for this, with ground for holding. Okay, so Georgia specifically passed properly indexed to be a part of the requirement. But now we got to go into even deeper questions, and it has not been, it might have been resolved by somebody, but it has not been resolved to my satisfaction that we even actually have a working definition of what the record is. Now, there might be one, and I just don't know about it, but I looked hard. And it seems like we in Georgia have two ideas that kind of conflict on what the record is. Well, what are you talking about, Mashburn? Well, I'm talking about the concept of constructive notice. Okay, so there's actual, Georgia's a race notice state, which means first to the courthouse without notice of somebody else having a prior claim. First to the courthouse, race, without notice of a prior claim, race notice. All right, so Georgia's a race notice state. Now, you can have actual knowledge of a deed, and therefore, if you have actual knowledge of a deed, that eliminates your ability to claim that you didn't have knowledge of it. All right, and so because you have actual knowledge. Well, the problem with that is that there's nobody in this room and nobody on our internet viewing it. People lie. They have notice or not. So it might be that people lie about it. And so we have to protect ourselves against people who lie. And the way we protect ourselves against it is, well, if it's in the record and it's properly indexed, you're going to be subject to that whether you know it or not. And what's the word in the law that we use when something is deemed to be something that it is not? Constructive notice. Now, how many people in law school studied the case of Regina versus Ojibwe? Virginia. Okay, there's one. All right, well, what this was a case where a indigenous person was riding a horse in the streets of down the streets of Montreal, and he couldn't afford a saddle, so he was riding on a feather pillow instead of a saddle, and the horse tripped on one of the sewer grates and broke his leg. So he shot it to put it out of its misery. But he was charged under the Small Birds Act with having killed a small bird. And Ojibwe, of course, objected and said, wait a minute, it's a horse. How could it possibly be a bird? And the court said, well, it was covered with feathers. And a bird is an animal covered with feathers, and this had feathers on it. And so therefore, it is constructively a bird. Even though it's not, we're going to call it a bird. All right, so then there was this giant uproar about, well, this is unfair. How is this guy in jail on these bogus charges? And so they investigated it. And the first thing they looked at is they said, well, what crazy judge issued this opinion? Blue, J. Blue J. Uh-oh. And it turns out that it was a prank done by some law students up in Canada, and it was a total joke. And they wrote this opinion just to be funny. And it somehow got into the reporter system and got reported. And so, but you learn it to learn the concept of constructive. And so now everybody here in this room will always remember when they're down at the courthouse looking at a record and they rely on constructive notice, or they think about constructive notice, they'll thank Judge Blue J for the idea of constructive notice is now firmly in your mind. Okay, so we deem you to have notice of something that you don't have notice of. All right, and the reason that's there is because people will lie about whether or not they have actual notice. Now, what's the third kind of notice? It's finally become fetch. No, y'all are tired, huh? All right. The third kind of notice is inquiry notice. Inquiry notice. An inquiry notice is you're deemed to have knowledge of the truthful answer of the question of by what right are you here? Okay. Primarily find this in relation to tenants with rights to purchase, especially. But they're like, you should have inspected the property, and had you inspected the property, you would have run across the person living there, and you would have asked them the question, by what right are you here on this property? And they would have given you a truthful answer. I'm a lease purchase. I've got a right to buy this property for less than your loan amount. So I'm going to wipe out your lender and pay them less than they're owed. So inquiry notice is the third kind of notice. So we got constructive, actual, and inquiry notice. And so we're dealing today with constructive notice, what's in the record. Okay, so you're charged under this McLeod case, you're charged with constructive notice of the contents recorded within the purchaser's chain of title. Recorded within the purchaser's chain of title. Now, the big divergence about what is the record, the big divergence is, well, there's cases out there that says the record, something's on the record as soon as you file it with the clerk. Okay. But then wait a minute, we're talking about it's not in the record until it's properly indexed under Title Standard 2.2. So you see how those are potentially in conflict or in conflict. Okay, you see how that, but wait a minute, is it properly indexed yet? And so I'm giving you some other cases. This was a case where this Nodman versus Plantation Pipeline Company is a case where it got recorded in the wrong book. And so, but they're saying, well, if you're the grantee of that deed and you filed it with the clerk, you've done everything you can do to make sure it's of the record. It's the clerk that messed it up. So we're not going to hold you responsible as against a BFP because the clerk messed up, because what you've done everything you need to do to get it recorded. Well, is that actually true? And here's the conflicting idea of that is, well, if the deed is misindexed, you might as well have buried it in the woods somewhere. And no, because nobody's going to find it. Well, you might find it. And so the title examiners out there, I can feel it. Their head, not in this room, but nothing against the people in this room, but we can feel it out on the internet. People's heads are exploding all over the internet right now because they're worried about this idea of, now wait a minute, I'm responsible for something that the clerk misindexed, but just because the grantee filed it. That didn't sound very fair. No. Who should carry the burden of the loss? Who should carry the burden of the loss? And so there's a case back in 1873. We're talking old law, capital L law. But 1873, long time ago, 150 years ago, the index is for the benefit of the searcher. So we're going to put the loss on with regard to the searchers, not for the benefit of the holder of the deed, because they're the ones who recorded it. So the index whole purpose out there is for the examiner, for the searcher. Oh, the other part, I should have done this in the introduction. The interesting thing, or not the interesting thing, but the conundrum today, well, maybe not even the conundrum. What's going on today is I don't have the answer for you today. I don't know how we're going to fix it. What we're going to do today is we're going to start the discussion of how we're going to fix this. And everybody's going to join the Title Standards Committee so they have a voice. You don't have to be a member of the executive committee to join the Title Standards Committee. You can be a member of the committee just by being a member of the section in the bar. So everybody's going to want to join the Title Standards Committee to have a voice in what we're going to do to try and fix this. So today is not to give you the answer. Today is to give you all the questions that are involved. And so the title companies are going to be involved, the title examiners are going to be involved, the closing attorney is going to be involved, lenders are going to be involved. So whoever I can think of is going to be involved in what the answer is, but we don't have the answer today. I'm sorry. We're starting the discussion of the answer. So this is the beginning of the beginning of the beginning today. All right? Okay. So sorry about that. Okay. So is it actually true? Is the record a shield? Is the fact that something's on the record and you can find it, is that a shield for the examiner? Or is it a sword that the examiner can use? But doesn't the record act as a shield? I'll pose the question. This is me. Pose the question. Doesn't the record act as a shield to protect the grantee and just to bring everybody up on the same page, because they're new people here. Welcome. I'm glad y'all are here. Welcome aboard. But so the RTV stands for the record title vested. So RTV, all that is a short and easy way to phrase it. Somebody who's purported to be the owner, somebody we think is the owner. All right, so the RTV, record title vested, but doesn't the record act as a shield for the RTV to avoid losing priority against the BFP? Okay, because they're of record. So once it's of record, you're protected forever. But when is it of record? Is it when you file it with the clerk? A lot of cases say that. Is it when it's properly indexed? Title standards say that. What's the answer? Don't know today. We're starting a discussion about it. Okay. So the record, depending on what the record is, does, but the index now under ground floor holdings, maybe not. Maybe the index doesn't protect you. Whether something's in the index or not in the index, maybe that doesn't protect you after all. Okay, so here we are back to the concept. They're like, give me a site, Mashburn, just because you said it. All I want to do for the past 10 years is be cited in something, but nobody will cite me. So give us a site we can use, Mashburn, but not you. All right, so here we go. Chatham v. Bradford, 1873. Once you filed it with the clerk, you've done everything you need to do. And that case actually came out in 1873 when the clerks actually got elected on their penmanship because they hand copied the deeds into the record books. For the millennials out there, there was no such thing as copiers. No, this crowd's tired. Y'all are tired. y'all had a long day. But yeah, there's no copiers, so they hand wrote each deed into the books back then. So that was interesting. But the owner, once he's handed it to the clerk, they've done everything they can possibly do. They can't. All right, so now I'm going to really blow your mind. We're gonna go back in the Wayback Machine. Okay, boomer, do it. Here we go. We're gonna do it. All right, so the difference between today's date and the date through which the records are good down at the courthouse, that's called the gap. Okay, and so under the idea of constructive notice, you're subject to something that's in the gap without the ability to search it because the records aren't good through that date yet. Okay, so it's filed at the courthouse and you're subject to it based on constructive notice, but you don't even know it's there and you can't even search. All right. In the old days, when the dinosaurs roamed Georgia, we, the young associates, the news associates, actually got sent to the courthouse and we looked through and read every deed in the gap in order to make sure that we weren't subject to something we didn't want to be subject to. Didn't know. The associates had to go down to the courthouse and read the deeds in the gap. So now go down to Fulton County, it's like 18,000 deeds in the gap. So they just laugh at you today. But back in the old days, we actually did it. We went down to the courthouse and read the deeds in the gap. All right, so that was an interesting aside, but it means nothing. So let's keep going. Okay. In the instance of the failure, we're talking about the burden of loss again. In the instance of the failure to record, the loss falls on the grantee. Okay, and so I had a post-closing paralegal one time, and she had a problem with recording stuff, and there were things in her drawer of woe. If you got that inside joke, but there were things in her drawer of woe that we were worried about, and so I tried to tell. I said, I want an unrecorded document to be a burning ember in your brain, slowly driving you crazy. And she goes, I can't handle that kind of pressure. I'll quit. so that didn't work. All right. But once, and so I tell the new paralegals, I'll say, once this document's of record, what does record mean? But once this document's of record, we're protected forever. We're safe. And I can fix. And so Patrick just gave an excellent speech, and I'm having flashbacks because I had every single one of those closings that he just talked about. I've done every one of those. All right, but so I've even forgotten what I was talking about now, but because I'm having such intense flashbacks. But so we tell them now, say once it's recorded, we're safe. And if you send the totally off subject, but if you send the payoffs and you record the deed, I can fix anything other than that. Those two things you got to do. Anything else I can fix, but those two things I can't fix. So get it of record as quick as you can. And so the when we're talking about the burden of loss, who should bear the burden of loss? Well, the grantee's got a pretty good argument because they're saying, as long as I'm unrecorded, I'm at risk, but as long as I'm recorded, I'm safe. So if I do the things necessary to be of record, I should be held harmless. So that's a pretty good argument as we start this discussion. All right. But as the index, the instance of the failure to index properly, the losses between the grantee and the purported BFP is going to fall on the purported BFP. All right. And it's again, bona fide purchaser for value. So as we keep going, well, what about the purported BFP and the clerk? Okay. So apologies to all the clerks out there, but there's a case, Chatham v. Bradford, that says if the clerk fails to do the clerk's duty, the clerk injures those who desire to search. So the duty, therefore, is to the searcher and to the public and not to the holder of the deed. But here's the Chatham versus Bradford for everybody in this room and on the internet who doesn't represent clerks. You'll want to have this case because this says it's the clerk's fault and the burden of loss ought to fall on the clerk. And that's why clerks have to post bonds. All right. And so now you ask out there, you go, Mashburn, why isn't Ground Floor Holdings a suit against the clerk who made the error? And that, I don't have an answer for that. I don't know. I do not know the answer to that question. Why it wasn't a clerk's case. All right. So Now let's go back and say, all right, management, I've never heard of this Ground Floor Holdings case. Tell me what was going on, because you've now given a 30-minute speech about something that I hadn't even heard about until today. And you're talking like I've read the case and I didn't even know about it. So tell me about the case a little bit. I said, okay. So here's the cast of characters in the case. We had a borrower, 230 Goshen, who filed a deed to secure debt with CoreVest, and that's the one that got misindexed. Okay. And then there was another lender, Velocity. They were going to make the loan, but they backed out and didn't do it. And then there was Ground Floor, the noble and honorable and good, reputable and highly wonderful lender that we represent. As the innocent victim in all this, who didn't do anything wrong and is wonderful and terrific. So all this disclosures are out of the way now, right? So Goshen then deeded the property to Flourish Home Investors, and Flourish Home Investors granted the deed to secure debt to the honorable and wonderful lender Ground Floor. And so Ground Floor, when they made the loan, they sent the title examiner down, and they say, well, go check the title and see if there's any deeds there's any open loan deeds that we need to worry about. Title examiner went down there. Nope, don't find it. Title examiner put in the title letter, didn't find a deed to secure debt, you better inquire. Okay. We'll talk about that in just a minute. Just hold that. All right. So, so I'm dating myself now. There used to be a show called Rowan and Martin's Laugh-In. And everybody in the country watched it on the say, everybody watched it. And they had Artie Johnson, he played this little character kind of hid in the bushes, and he was just, that's very interesting. The German accent. So you probably ask your grandparents about it. They laugh their heads off to that little skit. All right, but so this is Artie Johnson looking at this going, this is interesting. Goshen got misindexed 3 times, 4 months apart, January to April, 3 times, and it got misindexed 3 times, and all 3 times were the same attorney. So say it again. That's very so that's just an interesting aside. Okay. So here's the issue. This is me thinking about the issue. Here's the issue is the clerk misindexed a deed from 230 Goshen Investment Group as 203 Goshen Investment Group. Okay. So now in the old days, when we looked at books, the entry 230 Goshen and 203 Goshen would be absolutely next to one another. Okay. And this is what we're going to talk. This is kind of the setting the framework to have discussions about this, is because the way title exams are done has changed dramatically. And so today we run our title exams largely on the computer, and the computer is the best analogy I can give is you're looking through one end of a straw, and you don't see the entries next to it in the book like you used to. If it ain't in the straw, you don't see it. Okay. So an exam for 230 Goshen will not pull up 203 Goshen on the computer. You absolutely will not see it. Okay. And that's completely different from when the days when Title Standard 2.2 was passed by the Georgia Bar. The way we do title examinations has completely changed. And so as we talk about what we're going to do, we need to recognize that, and we need to talk about how computer searches are done. Because in the old days, you would have absolutely have found it. It would have been the next entry. So how could you miss it? Okay. So now I'm going to repeat what I just talked about.
excuse me,
Yeah, go ahead.
but wouldn't at the examiner at this point, even online, when it didn't bring up a 230, wouldn't that be a red flag as to something's wrong?
Well, we repeat the questions, is like, well, if the attorney didn't see something they were expecting to see, wouldn't that be a clue that something was wrong? Right? Okay, and the court actually makes that point in that they said that the title examiner wrote in his title exam, I didn't find a deed to secure debt, you better inquire. And what we, before on September 15th, 2025, thought was that's a way to protect yourself. That's a good shield to say, hey, people, I'm throwing up the red flag. Y'all better make sure you have a really good owner's affidavit because I'm not seeing something here. You better inquire. And the court actually adopted the position you stated, and they said, well, you knew that something was amiss. You should have looked harder. You were on notice that something was wrong, so you should have looked actually harder. So there's actually support in the court's opinion for that thought. So the court talks about it. Like my title examiner friendly view of the world is, they're saying they're throwing up the red flags for the people who ought to be checking on it. And that is the closing attorney and the owner's affidavit. And so the question in my mind was, well, what does the owner's affidavit say about deeds? And why can't somebody be thrown in jail for false swearing on the affidavit? And I don't have an answer for that. So I don't know. It's not in the record. It's not in the opinion. It's not in the opinion. Okay. So here we go. And here's, as we talk about how we're going to fix this and what we're going to do about it, the thing to remember is okay, let me back up for just a second. The court, in their opinion, talks about, well, what kind of examinations would have found this? And so the court wrote that the clerk said that if you had searched the word Goshen all by itself, you'd have found it. But if you actually go back in the transcripts and read the deposition testimony, what the clerk actually said was the attorney asked, well, if you search the word Goshen, would you find it? And they said, I guess so. So their answer was a lot less definitive than they gave than the court was giving them credit for. All right. So they're like, I guess, I don't know. Well, I went ahead and did it myself, and I searched it myself, and absolutely the search of the word Goshen on the computer did not find it, either in either capacity. And the reason why, as we discuss how we're going to fix this, the reason why is it will find errors after the word, but it will not find errors before the word. So, and I got some examples over here.
So any number before a word.
Anything before the word.
Anything.
Yeah, anything before the operative word, it won't find. And so here's me saying it again. Here, give some examples. So a search for the word Goshen would find any kind of misspelling or misindexing after the word Goshen. The problem is, and the problem in this case, is it will not find errors and mistakes before the word Goshen. So, ask your grandparents about this one. There used to be a book called the Yellow Pages. And back in the day, we used it to look up businesses. And so you wanted to be first. You want to be the first entry under attorney's order. And so the word Aachen, a city in Germany, was a way to get in. And then like, well, no, I can even get in front of Aachen by saying a Aachen. So that's a throwback to the Yellow Pages, just a very insider joke for your grandparents in there. But any permutation before the word Goshen will not show up in the computer. So as we're talking about how we're going to fix it, that's an important detail to have in mind.
Depending on the computer system, they normally require the first 2 or 3 characters in order to even complete a search.
Oh,
So some of them will let you do a wild card. It's normally an asterisk, so you might be able to put in GOS asterisk. And it would pull up anything, like if they left off the H, it might pull it up. But you have to have those first couple of characters correct.
ah,
I just did a wild card search in Fulton and DeKalb and it doesn't hit.
it does not hit.
No.
You just ran it right now?
Yeah.
From your computer in?
Yeah, I assume it's Fulton or DeKalb.
That's awesome.
And,
I think
yeah,
this one's Richmond.
it's Richmond.
Yeah, it's actually happened. This was in Richmond County.
Do that.
I changed the names to protect
Dennis.
both. But,
Nope,
but no, not,
doesn't like wild card.
not, okay. So as we talk about this, how we're gonna fix this, this is an important detail to have in mind. Okay. And so the problem is the court did not tell us what the standard was. They didn't say this is the new standard, we're replacing the old standard with. What they did, what the court did was they just said it's a jury question. Now, for the litigators out there in litigation world, the closest to not giving an answer on anything and just and not doing anything, we're not going to do anything about this case, is just say it's a jury question. Okay, no summary judgment, no new law that way. No, if you just if you give it to the jury, you haven't, in the litigator's mind, you haven't done anything. You just said, let the jury decide it. We're not going to decide it. We're not going to make law here. The problem for title examiners is this took something that was summary judgment and made it a jury question. And so in real estate world, in title examiner world, you've completely changed the entire structure. Okay, just saying, well, it's a jury question, no summary judgment was not making law, it actually made law. Okay, so I don't know if it was me on my soapbox or not, but maybe. Okay. So here's the kind of the question you just brought. Currently in the computer search, there is no contains. Now, if you search a corporation's name, like Patrick was telling you to do in the last presentation, if you search a corporation's name on the Secretary of State, you have the option of saying contains, and so that would pick up any Goshen before or after, because it just contains the word Goshen. And so that's the way the Secretary of State's website would actually not have this problem, because it would show up. So maybe we need to talk to our friends, the GSCCCCCCCA, and ask them to say, hey, can we have a contains? How many dollars would it take? How much recording costs would have to go up to get a contains option? And it might be 70 million, it might be 100,000. I don't know. I don't know. But as we talk about it, certainly they'll want to have a place at the table to give us the answer to that question. Okay. All right, so possible solutions. Well, this court, or the judges on the court right now, Court of Appeals and Supreme Court, are pretty much the strong majority is in favor of freedom to contract. So what's the first thought you do is, well, let's alter what our contract says. Okay, so incorporating Title Standard 2.2 by labeling it 2.2, in Mashburn's opinion, probably not the best idea, because it's been changed. It hadn't been changed by the Title Standards Committee, but it's been changed by the court. So referencing it by number, probably not a good idea, but maybe making that your scope of work and use the words instead of the reference to title standards, but use the title standard as your scope of work and say, in doing this title, I'm going to search for properly indexed deed. Okay, so that's one idea. And if you do engagement letters, you probably don't do an engagement letter for each title. Some banks require you to do an engagement letter for each closing. And so if the banks are sending you engagement letters, maybe you have a discussion with them about what we put in our engagement letter with y'all. Okay, just not a recommendation, not practicing law, not giving you advice, but just things that we got to think about as we process this as we go through. Okay, maybe put a disclaimer in your title letter itself and give them an explanation of what just happened in ground floor. And then say, there is no standard for what I should have found anymore, because it's impossible to figure out how many possible misindexing possibilities there are. All right, because, you know, I was trying to be clever about it, and I did. Do you remember in factorial, when you're in 8th grade, you learn factorial is this number times this number times this number times this number, 5 factorial, 5, 4, 3, 2, 1. And so it tells you how many combinations things could do. So I was like, but the combinations are infinite. All right. So maybe you put that in there. Maybe again, continuing with the idea of putting in disclaimers, maybe you put in further disclaimers that it's Title Standard 2.2 in effect today. And now it might not be so hot because Title Standard, because there's a question of what is the Title Standard really in effect, or has it been reversed by law before the Title Standards Committee's had a chance to act on it? And so maybe you take specific exception for misindexed deeds. Okay. Now, I got to give credit here to Joanne Capilotto. She's out there listening, because she's thought a lot about this and has some really helpful language that she suggested. And so anything in these suggestions that you liked are credited to her, and anything you didn't like or hated is credited to me. Okay, because she's thought a lot about, she's really put in a lot of thought about this and trying to come up with solutions and ideas. So special credit to her. She's got a place in heaven right next to the University of Michigan Law Librarians for being helpful in preparing this. So thank you to her. All right, but possible problems. You can't waive negligence by contract, so you're still subject to that. So be careful about you're not trying to limit your liability or do waivers. So you want to don't talk about it in terms of negligence or liability or waivers. Talk about it as the scope of work. Okay. Now here's a big one. Don't do anything at all. Do not pass go. Do not do anything until you've talked about it with your title company. If you're an agent of the title company, because you might be putting yourself in violation of your agency agreement. So just stand here, just stand there like that. Don't move until you've talked to the title company to make sure that they're in full agreement with whatever you're doing. Okay. Okay, so how are we doing on time? I got 20 more minutes. Oh my gosh. I got to make sure y'all get the full hour. So now we're gonna open it up for ideas, discussions, thoughts, and then if not, I'm gonna go back and do more talking on stuff I've already talked about. Tell more jokes that you don't get or don't like. All right, but thoughts, ideas, recriminations, this Mashburn, you're getting worked over something that's not even a problem.
Yeah, so I apologize. I'm one of the new guys you talked about. So
welcome. We're glad you're here.
Forgive my ignorance on this. But I really liked what you were talking about with the more powerful search query, basically in the government websites for titles. Do you think that potentially integrating some version of that with AI, or in a way that we can actually get what's prior to that word? Because if we give an AI the database of all the deeds, it will actually be able to search it in a much more complete way than what we're currently working with. Do you think that's a quicker solution to this than? Yeah,
Louis, don't want us to repeat the question because you don't have a mic. So let me repeat the question and I'll try and rephrase it and I'll check to make sure it's right. But that you were liking the idea that it could be handled through possible programming. And that's why new people are important, because old people will go, we'll never be able to fix this. Because computers are complicated. But the young people are like, well, the computers can fix this. We can do this. All right, so the question is, can we really pursue the idea of maybe adding the contains language or wildcards, or is that a really good, or you want to, you know, voice support for that idea? And I think that's definitely one of the ways to address it, because if there was a contains option, I don't think this problem would have happened in the first place. Because it would have been apparent that it's there. Now, the title examiner might have said, oh, not us. And so the title examiners that have more of an inquisitive mind versus less of an inquisitive mind, maybe between title examiners, somebody would have found it or not, but at least opening up the opportunity to make it more like the book where you see things would be an idea. And so, you know, mental note to the title, and actually the Title Standards Committee is also looking for new people to add their ideas and thoughts. So please have that in mind. But that's a great, I think that's a great thought. That might be the answer. That might be the answer is we got to handle it through expanding GSCCA's ability to search things. And in fact, the courthouses are supposed to keep their own records and they're supposed to keep their own books, but I've found that to be very spotty. And there ain't 159 sets of books out there. I'm not gonna call names yet. This is how much time we have. I might get the next 5 minutes by calling out names, but if you go and ask for the books, plenty of counties you can't find them. Okay, but right behind you, an idea.
I'm an old attorney, but new in the area, so qualifier. So following along with his idea, even if you were to use AI or change the search tool to say contains, do we need to still look at how that impacts Title 2.2, because the obligation is still on the examiner to search for properly indexed and recorded instruments. So how does that modify then the title examiner or something?
And so the question was, let me paraphrase it, doesn't 2.2 still need to be rewritten to take into account these new options? And I think absolutely it's going to have to be rewritten. Now the next question, the follow-up question is, well, why hadn't it already been rewritten? And the answer to that is, this is a new case that I don't think there's even been a time where the title standards get amended since this has happened. So
We're in that process.
yeah, so they're looking at, so this is their first opportunity. They haven't presented revised title standards to you since this happened. So this is brand, so y'all are the cutting edge. Y'all are the avant-garde of the law today. But yeah, that 2.2 is definitely going to have to be rewritten. And you know, it might take a while because there's a lot of stakeholders, and we're talking about real dollars, zero-sum game. Who's going to bear the loss? So you know, the world has changed, and the risk of loss has changed, and it's going to be reallocated. So everybody wants to be involved in that reallocation. Let's not tax me and let's not tax thee. Let's tax the guy behind the tree. Right? No? Tired? We had it. We're done. Okay. But good point. I like it. Other thoughts?
So do you think this will be on the agenda for the real property section this year to update that section?
So the
Based on
question
the
is,
case?
the question is that a reason I should come to the RPLI so I can vote on this?
There you go.
Yeah, and that's a good point, is that if they have enough time and can work it through, I would expect it to show up at the RPLI, but there might not be enough time, so it might be the next RPLI that this finally gets addressed at. Oh, wait a minute, we got an official word.
Susan and I chair the Title Standards Committee. We are in the process of doing our annual update of the title standards. So I'm going to use this beautiful opportunity that Matt has given us to invite everyone here and everyone online to join the Title Standards Committee. All you have to do is be a member of the bar and email us to tell us you would like to serve on the committee. That's pretty much it. Once a year, we send out a call to the committee members and ask if they have any input on any of the title standards. 2.2 is obviously the hot topic this year, and we are looking for our members' input. If you have ideas about what the language should be, or have ideas about how we should change it, or any other title standards, or want to suggest new title standards, we are more than happy to hear those suggestions. Especially if you would like to take on the opportunity to write the title standard or modify the language yourself and suggest modified language. Once the committee members have given us their suggestions, we take that to the executive committee. The executive committee gives us their input. We will then take that input and give it back to the bar at or the section at large. Normally those comments and those proposed changes are published through the listserv. So if you're not on the listserv, I do strongly suggest you join that. And then we have a comment period, normally about a month. So that normally comes out about mid-April. And then, as Matt was saying, the final title standard revisions are voted on at the RPLI at our section annual meeting. So if you ever have a title standard that you want changed or revised, that's the process. And we definitely invite you to come be part of that process.
Very good. Excellent. And correct me if I'm wrong on this. It's the third day. It happens, takes place on the third day, right?
I think they're holding the meeting maybe day one this year.
Okay. There you go.
I would have to confirm that.
Okay, so we'll pick on that too, but yeah. It'll be very important to be engaged on this one. Okay, other thoughts? Thank you for the question. Other thoughts, ideas, recriminations, condemnations? Are we doing on time? We're good?
We got a few minutes left.
We got a couple of few more minutes about something that I might have skipped over that's important. Again.
Well, so two more things. One, we do at the next title standard section 2 weeks from now, we do have a section on AI and examinations. So if you're interested in that topic, that is definitely one to attend and hear. Also, and this is more, I'm a millennial, so I don't like picking sides about technology versus the old way of doing things. But one thing to keep in mind with respect to the way that title searches are run is that anything that allows an examiner to search more information is going to slow down your search, because then they have to search more information. So if they have the option to search a contains, they have to search that contains, and then they have to sort through all the results. So if you have John Smith, not only would you have to search, the 100 John Smiths, you have to search everybody who's Smith, J. You have to search everybody who's just Smith. And then if it's contains, maybe you start getting me Smith as the name. And all of a sudden you have to search all of those people too.
Yeah.
So there are ramifications to expanding the option to search. I'm not saying it shouldn't be done, but that's just a consideration.
And so just to repeat the question is, there's a potential drawback to adding contains, and it's the William Smith problem, 5-phase, or John James problem for 5-phase. And for the people that are new out there, that is, well, if you open it, since title examinations are done by way of exclusion, I've excluded something. If you increase your hit, you've slowed down your title search, because now you've got to go, instead of 3 entries in the 5-phase index for Marshall Lichtenstein, there are 14 pages of John James. And so do you have to go search every John James, you know, what do you do on common names? So your contain might hit a prohibitive number of hits that slow you down. So again, something we're gonna have to figure out on how to do that. All right, so I think we've hit close enough to your hour. All right, you get the credits. Yay, thank you for your attention. Thank you for having me. I sure appreciated starting this discussion with y'all and look forward to see how this goes. And thanks for coming today.